Hello and welcome to 4IP Council's webinar, Managing Your IP. My name is Claudia Tapia. I'm the chairperson for 4IP Council, and I will be your host today alongside Dana Colarulli, Executive Director of the Licensing Executive Society International, also known as LESI. As you may know, 4IP Council is a not-for-profit research council developing high-quality academic insights on topics related to intellectual property and innovation. Today's webinar is the first in a series with LESI and has been marketed with IP Help Desk, who I'd like to thank for their support. 4IP Council offers an extensive body of detailed research addressing current intellectual property and innovation themes. We also conduct education activities, including the creation of resources to encourage innovative SMEs to grow their businesses using IP. And among these resources, you will find interactive graphics complementing topics your presenters will cover today. Visit our website for a range of free materials. The slides and a recording for this webinar will be made available on our website tomorrow. If you have questions to the speakers, please post them in the Q&A area on your screen. Now, without further delay, Dana, the floor is yours.
Thanks so much, Claudia, and I'm excited to join you all today, partner with 4IP Council, and to talk about the three publications that we at LESI published just last year, addressing the critical issue of managing your IP. By way of background, I am Dana Colarulli. I'm the Executive Director of LESI. I'm a US-based attorney and spent most of my career focused on IP rights, both in the government and in the private sector, and working with a lot of chief IP counsels from a number of firms.
Dana?
I'd like to tell you a little bit more about LESI first, and I'm going to take over the
screen, please?
I'm going to take over the screen share here.
Thank you.
So who is LESI? LESI is, I hope many of you are familiar with the organization. It's an umbrella association of 33 national and regional member societies in more than 90 countries, serving more than 7,000 individuals. We provide a global platform that enables businesses, professionals, and industry players to network, to learn, and create a network that can help further their own professional careers and hopefully help them understand developments throughout the world, in fact, affecting licensing. So we're both an educational network and a professional and social network to help support our members. We believe in the value of IP as an enabler that drives today's innovative technology to the marketplace. We do this in a variety of ways, including through meetings and networking opportunities, publications, and engaging with public and private entities to advocate for landscapes. And our annual conference next May in 2020, which will be a 100% virtual conference. We had intended to be in Seoul, Korea, but instead may host LES members globally via Zoom this year, as many of you have done in your own work. In this case, I guess we'll be in Korea, so we'll toast with some soju. So let me introduce both our three authors for this particular publication and talk a little bit about the series. So last May, we published three publications. This is the first of the three, Managing Your Intellectual Property. We also did a second publication on licensing your IP and a third publication on valuing your IP. So three critical issues to be able to effectively consider your IP, manage your IP, and help you get it to the marketplace. The first of the series, this is the first of the series. They were all published last May. They're written specifically for SMEs, but really useful for a much broader audience than that. For those involved in the business of IP for the first time, these briefings provide critical information that may help your enterprise be successful, certainly will make you more knowledgeable about how to effectively approach the marketplace, how effectively to approach your IP to ensure that it displays the value that your company holds for prospective partners. The 3 briefings were written by LES members, including the 3 people I'm going to introduce, who are experts in their subject and active in licensing in various markets throughout the world. So this is the first of 3. I hope you'll join for the next 2. But let's get this one kicked off. Don Drinkwater is the Director of Licensing at Bose Corporation in Boston, Massachusetts, here in the US. He was a critical driver for the series of 3 publications, but also particularly as an author of this publication. Second, Nikos Minas is a European patent attorney from Hanna, Moore and Curley in Dublin, Ireland. He was an author here of this publication. And third, Jim Malackowski, Chief Executive Officer of Ocean Tomo in Chicago, Illinois, again here in the US. So if you have questions during the session, I ask you to post them to the Q&A area on your screen. But let's get to it. Don, you're going to help us through this and lead us with the first part of the presentation. I hope this will be a bit more interactive. So after you give us an overview of the publication, we'll go through some questions for both you and the other 2 authors. Don, I turn it to you.
Thank you very much, Dana. Good morning, good afternoon, good evening, depending on where you are in the world. This is my first LESI presentation, so I hope I make it enjoyable, fun, and a learning opportunity. Dana, could you advance the slide, please? So, intellectual property is at the core of commercial success of organizations, and effectively managing it enables you to kind of more optimally convert your innovative ideas, your expressions, and what would be intangible assets into tangible business assets. And that, I believe, is critical toward the success of any company. Dana, you can move. Many of you have probably seen a slide like this. Ocean Tomo put this together for us for this presentation. And what it shows is the relative value of your intellectual assets compared to all the assets of a company. This has been going on for quite some number of years, as you can see, starting in 1975. And back in 1975, for those who were born then, I certainly was, the assets of a company drove the most significant part of the value. If you think about a company that built cars, you had manufacturing plants, you had very sophisticated, expensive equipment. So you had a lot of tangible assets that would help manufacture that automobile. As we progressed, and as particularly if we think about all the how much software type products contribute to our economy, we realize less and less it becomes about your plant and all the equipment in your plant, and more it becomes of the intellectual property. If you think about a company like Apple, of course, they have beautiful facilities. I've been fortunate enough to visit their spaceship. But really, it's the products that just drove the company to be, I think maybe the most valuable company in the world, or certainly one of the most valuable companies in the world. And just as we look at all successful companies right now, we're really seeing it has to do with the idea, how they protect their ideas, and then how it gets commercialized. Dana, can flip slides, please. So the primer, we're going to follow the primer basically. The primer has more details. And of course, there's no end to details. As Dana indicated, the primer is really for someone, it's for everybody. In fact, I found it a great review as I was working on the management primer. And then as I read the other 2 primers that Dana spoke of. So I think it's probably a good refresher for everybody. But it really is good for people who are new and also for companies that are small, medium-sized organizations. So we're going to talk about the types of IP. We're going to talk about how to develop a business strategy for your IP, protecting your IP, monitoring and assessing your IP activity effectively, and establishing processes and policies, which we're going to term guiding principles to keep you on track. Dana, please change. All right, so types of IP, I think that we're all very familiar with these, except for the last one. We're going to get that in a minute. So patents, trademarks, industrial design, copyright, trade secrets. And you see this item called data ownership and privacy. They kind of go together. Speaking for what I do, and I'm in the, as Dana indicated, I work for Bose Corporation, which is a consumer electronics company. Data has become a significant negotiation point in all our license agreements. Normally, I think that your first blush would be, what does data have to do with a license agreement? Well, the fact is that, a lot of license agreements now in my world have to do with cloud-based technologies. And cloud-based technologies are collecting data. And who owns that data? We know that, and then privacy plays right into that, because you can own all the data you have, but you may not be able to do anything with that data. And we know that there's laws such as the Gdpr in Europe that have come in to protect people's privacy, which is a very good law. Most companies, even though they'd be located in the United States, they're still going to follow the GDPR, because you don't have, it's difficult to have multiple systems handling such sensitive data. So this has become something that's really new. We know that if you think about Facebook, if you think about Google, their IP, their intellectual property really is the data. And we know that in many cases, we think we're the customer when actually we have become the product. Dana, switch sides, please. So let's talk about developing a business strategy for your IP. First of all, you can just defend. And this may seem like something that licensing people don't want to do, but this is probably the tried and true reason for getting patents and trade secrets, holding trade secrets, and spend a lot of money developing your brand. You're basically holding the IP to protect your products, to protect your business from competition, and your IP creates additional profit margin because it creates value. You would tend to assert against an infringing company. Now, a few things have happened. In some industries, mine included, the problem is that they become, I won't say it's a problem, but dominant players have dominated the industry. And you can't assert patents against them. And what I've seen in license contracts, which has been around for a few years, but getting to be more common, are clauses that convert what otherwise would be a commercial license that has nothing to do with patents, but it brings in patents. Very simply stated, if you were to sue the company you did the deal with, that would be considered a breach of the agreement, and they could get out of the agreement. Now, you can imagine if you're selling 40 or 50% of your products through this particular company, and if you then sue them on patent infringement because they decide to build a product that's infringing your patents, they can take you out of their distribution, which is going to really hurt you and may even put you out of business. I think this is something that we're going to see governments start to take a little closer look at. A case that you might want to follow that's going to be very interesting, which recently came up, is Sonos, which is a competitor of Bose. Sonos sued Google. They felt that Google had stolen their ideas. Apparently, they had shared some ideas because they were going to do some work with Google. And we're going to see how that plays out. Now, one thing I think Sonos did, and by the way, I'm only speaking for myself here, not for my company, but I believe that Sonos made a very good move in this, in that they immediately got the United States legislature involved, which kind of put Google on notice that you have to kind of be gentle about this and how this is going to go. So we'll see how that all plays out. But that's kind of a case in point of what I'm referring to here. Now, defensive is clearly used frequently in pharma. I'm not in pharma. I don't know very much about pharma, but I know that drugs get protected, and that's very important for pharma, who have invested hundreds of millions of dollars and usually waited 10 years to get these drugs out. Offensive. So offensive is when a company. A couple of reasons for offensive. First of all, you may have some patents that you that people that you feel other people can use. I'm struggling. Sorry, a little bit here. So let's say that you're a startup type of a company, and you have a good idea and you have a product to bring to market. The idea of a carrot license, meaning that you're going to go out with your technology and with your patents and whatever other IP, and you're going to try to license that to a company that will commercialize it and bring it into the marketplace. Bringing the product into the marketplace is probably harder than actually inventing the product. At least I have found that personally, because you have to think about things like, how are you going to support this product? How are you going to manufacture this product? And putting all those items in place is expensive, and it's risky because maybe your product just isn't going to sell, and then you've lost all that money. So to try to find a company to take that technology to market is a very reasonable approach to bringing your IP to market. It's not easy to do. It's not easy to do because other companies, everybody is pretty busy. If you imagine yourself at work. Someone calls you with a great idea. You're in a company, you already have 5 or 6 products you're trying to get out the door, and you really you're not prepared for that call. So the person making the call definitely has an uphill battle, but it works many times. Then the other part is what we call the stick, and this is basically to licensing to infringers. I think we all pretty much know if you have a very valid patent, if you're sure about that, and if the company is absolutely infringing, you're probably going to win this. And but it's going to cost a lot of money. So you really better be right. Unfortunately, we also know that there are some organizations that have taken advantage of stick licensing and pretty much just played the game of it's easier for them to write me a check for $50,000 than to call up their law firm, which the first call might cost you $25,000. So that's using it in an offensive. And then we talk about a hybrid approach, which is basically that you assert your crown jewels to protect your company, but you license ancillary technologies that you've developed as you've gone along the way. Dana, can you flip to the next slide, please? So protecting your IP. Well, I think that you're all pretty sophisticated on this phone call. So you get patents, you register trademarks, etc. Use copyright, trade secrets, whatever. But there are other very important agreements that you need to pay close attention to. One is non-disclosure, kind of a mundane subject, the non-disclosure agreement, but it's very important that your company have a policy and that your workforce is very well educated, that when they're going to start talking about what is secret in your company, which they may have forgotten is a secret in your company because they talk among themselves all the time, that they have to fill out a non-disclosure agreement, get a non-disclosure agreement in place. And many companies have a process, a simple process where you fill out a form and a lawyer gets assigned and you negotiate the non-disclosure agreement. Business partnership agreements get a little more complicated. Business partnership agreements, when you say you're doing a joint development, and you want to know who owns IP. And you'll hear terms like background IP. So I have my background IP, which I've identified, and I own that. And we both understand that I own that, and no one's getting a license to that. And then the other company has theirs. And then the question comes in is, so now a couple of your engineers or your scientists are working together, and they come up with a way to improve the background IP. Who owns that background IP? That has to be discussed. And what even gets a little more difficult is what happens in the process of doing the development. It's new IP, and it's jointly developed. I think we all know in the world of patents, if 2 people are on a patent, they both own the patent. They can do what they want with it. And that's not really a good situation when it comes to a business relationship. So you want to make sure that you have clauses that at least indicate that the companies are going to be reasonable in discussing on what you're going to do, or who's going to own joint IP, and how it's going to be handled. Outsourcing agreement. So this, here I'm referring specifically when someone is building your product, like a subcontractor. Now, from what I understand, I'm not sure about this, but I believe that one of the standards that LES has been working on, that they have maybe got approval for a standard that applies to people building products. Just to give you a little bit of personal experience here, what can happen is when you bring subcontractors online, of course, the first thing is, can they build your product? How's their quality? And we have standards for that. I think like ISO 1000 or whatever they are. But sometimes you don't talk about do they have the proper licenses? So you're building a product that includes, I'll use for an example, and excuse me, I might not be perfect here, but a company like Dolby, Dolby's, they use a licensing model. In the consumer electronics space, we use Dolby because it decodes content and gives you these amazing sound experiences. But and again, I'm using this as a potential example. They may want be able to have a direct line into any company that's touching their technology. Well, if in the process of building your product, you have to, Dolby code is being loaded into a chip or something like that, that subcontractor has to have a license with Dolby. Otherwise, you're going to get the shock in your system that you're ready to ship the product, and you're going to get a call and say they can't do it because they don't have the proper license. And that's something that I think has been really overlooked by many subcontractors, particularly in other, in third world type nations. License agreements, obviously, you want to protect your IP in a license agreement. And then the last one here is employee contracts. And again, very important that when your employees join the company, they're under contract. For those of us who work for larger companies, this is like, are you kidding? You mean people don't have employee contracts? But you'd be surprised how many small companies and medium-sized companies don't really have good employee contracts. And they have to cover things like, the person's an engineer, scientist, they're working on their own time on a Saturday, and they come up with an invention. Who owns the invention? Some companies say they own everything. Other companies say, no, that can be yours. We just have to, have a process and talk about it. Right, Dana, next slide. So in the area of monitoring your IP, one of the things you just should do, and a lot of people don't do, is an asset register. What do you have? You start off as a small company. The general counsel, the lead attorney, or the lead IP attorney knows all this. It's in their head. But then as time goes on, well, depending on how smart you are, I guess you start to forget things. So you really want to have a register, a very basic register. What IP do you own? What products does it apply to? How does it protect those products? Getting more sophisticated, we see landscape analysis. These are patent landscape analysis that can do an awful lot for you. Many times you can purchase tools and do it yourself, or many times you hire people to do these landscape analysis for you. And these can help you determine how your patents compare against your competition. It can take a look at what your competition's working on. It's really a form of legal competitive analysis. You're not breaking into a company trying to steal prints. You have every right to do this. And it's based usually on forward citation analysis or backwards citation analysis. It's a very good tool to talk about and to use. Now, what you may find is that you have an underweight portfolio. An underweight portfolio basically means you really should have more patents or more IP, more copyrights, whatever, more trade secrets. A lot of times this does play into the world of patents. And so when you're underweight, you need to get more. And you can get more in a couple of ways. One is you can purchase them. And this has been around for quite some time, but I think more and more people is growing that people purchase IP. They usually use brokers to help beef up their portfolio. And then, of course, you can just be more diligent and you look for new inventions in your company and just file more IP. You may find that you have an overweight portfolio, and this is the opposite. In fact, if you have an overweight portfolio, maybe you sell to a person that has an underweight portfolio. A more difficult decision sometimes can be to abandon IP. after you've gone to all the bother and you know that you got the invention and then you filed it. But sometimes you find that the IP just didn't mature in the marketplace as you thought it would. You're not really using it. And there's just no sense chasing good money after bad money. So it's sometimes you just abandon it. Dana, next slide. And the last part of the thing I want to talk about is guiding principles. And this is just the roadmap. You want to make sure that you have a set of principles that will guide you. In my role, I get a lot of what I call unsolicited disclosures. And we have a process of how we handle them. And that's what you want to do. So when someone comes in, they can come up with an absolute great idea, but what do you do with it? You know, how do you review it? How do you make a determination of whether you want to move forward with this or not? Do you want to treat your IP as a profit center? Do you want it to be centralized? And you can see some of the other bullets on here, which I'm not going to go in details. But I just look at this is your guiding principles keep you on the road, no matter what's happening, because the world is full of so many distractions. But that doesn't mean that you don't take a right turn or a left fork as you're going down the road. It's just that you want to know that you're taking it, that it's still within your principles of what you're doing and how you made that decision and made it properly. So I believe now we're going to switch to question and answers. I hope I've added a little bit to this and helped everybody on this call along their journey.
Thanks, Don. This is Dana again. No, I think you've done a great job of kind of giving an overview of the publication, and you know, I mean, it just goes to show it's not enough to have a great idea. It's not enough to have your IP. You really need to come up with a strategy that works for your company to effectively exploit that IP. So we're going to get into that a little bit in the question and answer. In fact, you know, it occurred to me as I was listening to those last couple slides that, you know, for some of the audience, we kind of wrote this from the perspective of growth, but really towards SMEs. An overweight portfolio might be something they're aspiring to. It's a good problem to have. So, but let's talk about this strategy. Nikos, let me go to you first. Talk to us a bit more about the process of setting out an effective business strategy for companies looking to do this effectively.
I'll be glad to. Hello, Dana. Hello, everyone. Well, I'll tell you from my perspective and the way that I see it as a European patent attorney, I get to work with a lot of SME companies. And the first thing that strikes me is that SMEs are wondering, what is IP? What is IP strategy exactly? And what do you define it? Actually, IP strategy, and if we look IP in general, it's a tool that it should be part of your business plan. It's a way of achieving your business objectives together with other things that you should put in your business plan. And this is what IP strategy, that's where we start. It's defining what will be your business objectives. Is it, for example, to license your innovation, or is it to manufacture it, to put to put products in the market yourself with partners? And that's the first step where we actually try to initiate some contacts for the IP strategy to set it within a business environment. And then, of course, once we have that, we need to understand what the company has, what the IP is there to be protected. And it's always very interesting to see that companies, they talk a lot about innovation, but the proper context of innovation is where you have an idea or a product that is of commercial value. And IP really is about protecting this commercial value, this commercial advantage. And of course, once we have identified the IP that should be protected, we should review it, and we should try to understand in what form we should protect it. Innovation comes in many different shapes and forms, and they're not all equal. Some companies work in marketing, other companies work in deep tech. And that's why we have different forms of IP rights, protecting different forms of innovation. And this is what we should do. We should have a process in place that will help the company and the people involved select the right IPR, the intellectual property right for an innovation. And sometimes you need to use more than one IPR. A product, for example, that goes to the market, we can use the example of Bose headphones from Don. It doesn't only have patents. It will have the trademark as well. It will have the trade secrets. It will have the design and so on. So we need to create a holistic IP approach. Every company should think of broader than a specific IP right and continuously evaluate how those IPRs help the company achieve its objectives. And then, of course, once we know how to protect, we should do that. We should actually go and launch our application, either for a patent, for a trademark, and so on. And we should continuously monitor, and this is the key. Just because I filed one patent doesn't mean that that's it for the next 20 years. I don't have to do anything else. We should actually evolve our IP portfolio as our innovation evolves. IP and innovation goes hand in hand. And this is what companies and executives will have in mind, especially from SMEs. So these are the 3 easy steps, let's say, or 4, if you like, easy steps though, of establishing an SME an IP strategy in an SME environment.
Great, Nikos, thank you so much. Jim, let's hear from you. Part of the publication highlights what management needs to consider regularly to effectively evaluate and utilize a patent portfolio. Can you walk us through some of those elements?
Sure. Thank you, Dana. And in fact, I'd like to extend some of the conversation that Don started. If we could go back to slide 8 as an example.
Sure.
When we get asked that question by clients, what we try to answer first is, well, what is the contribution of the patent state to your shareholders or to stakeholder value? So as Don mentioned, we might first look to an analysis like this. Obviously, this relates to the market as a whole, but look to the importance of intangible assets to a given company. How much of your value is driven by that? We then drill deeper to understand the components of those assets, whether it is patents, trade secrets, copyrights, brand, or other. And that can be done with the portfolio analysis using analytic tools that Don mentioned. But ultimately, you have to put eyes to paper and look to claims and match those claims against product. So it's all about starting at the macro and driving into the detail. I would just note we've been performing this analysis now for decades, and we recently just published a paper showing that in the COVID environment, as expected, the intangible assets are becoming even more concentrated, up to 90%. And we're publishing a paper with Les Nouvelles this fall that will talk about what to expect after the coronavirus has passed. So we'll get into that detail. The other point I would just mention to extend on what Don did is look to slide 14, which is the guiding principles. And I would only emphasize that coming up with a set of simple policies or practices as to how you're going to manage your IP can be extraordinarily difficult. You may have different divisions with different goals. You may have different executives with different ideas. And we may spend several months to a quarter just trying to distill on one piece of paper answers to questions like, we will or we won't out-license our IP. We will or we will not license in. We are willing to enforce or we are not. And coming to a basic agreement on those type of guiding principles really is necessary in our view to effectively manage that portfolio for stakeholder value and get that intangible value that was reflected on the prior chart.
Great, thanks, Jim. I want to kind of go around the table now on a few questions, but we'll start with this, and Don, I can start with you, but others certainly add in. I guess at this point, so we've gone through certainly the importance of doing this, some of the factors that you need to consider as you're kind of looking across of what your value is in your company. What advice would you give to our audience about the correct IP to select for your innovation? What's the correct IP to offer to a particular licensor, licensee? How do you go through that process?
Okay, I think there's a lot to that question.
I think so.
So first of all, let's talk about what IP to get. And a lot of this depends on the industry, but I'll take you to it. It's something that I'm familiar with. You're going to build you're going to build a computer, a new computer or something like that. What I've learned is that what happens a lot is people come up with inventions. They're clear inventions. But then the question is, well, how do you determine which ones you should go forward and spend money to patent? And a lot of times the discussion will get around, well, how good is this invention and et cetera, can we get the patent? And of course, there always will be people around the table that there's no such thing as an invention because everything's been invented. And then there's other people that everything is an invention. But in the end, I'm not sure you end up with the right with the right answer. What I've done in the past is that you look at the product and you basically look at what do you want to protect with the product. In fact, this was actually in a different role with a different company when I was more involved with patent committees and things like that. And really, I'd almost start by asking the question, what do we want to protect? If we can, maybe we can't, but what do we want to protect? So kind of reverse it. Instead of the idea that the inventions are going to come up from the ground, which you want them to, you kind of get on a higher level and say, what would we like to protect? Because we know if we can protect this feature, this is going to be significant. And not only that, but you can't infringe it without everybody knowing that you infringed it.
Hey,
So
Don,
yeah.
Jim, I'd just like to extend on that because I think you're exactly right. Focus on what you want to accomplish. And I would add that having that portfolio of IP assets really is most effective. So if you can have patent protection, combine that with know-how, combine that with data, maybe a brand license, that's going to give you the proverbial belts and suspenders approach and maximize value, in our opinion.
Yeah. Jim, that was you, right?
Yes.
Yeah, thank you. You're absolutely correct. So, I was thinking more internal, but you're right. In the end, if you are now that smaller company and you want to bring this to a larger company as a license opportunity, absolutely, you want to have the whole package. I also just want to add that we cannot discount trade secrets. Sometimes you just keep things secret. If it's not something that people can see, they can't reverse engineer. A lot of times this will be more maybe in your manufacturing process, but perhaps not. A trade secret can be more powerful, than other forms of IP. Because one thing is it doesn't run out; it just goes on as long as you keep it a trade secret. And to have policies for how you keep a trade secret, that's also important. But to Jim's point, it's really using all the forms of IP to accomplish what your goal is, and make sure you know what your goal is.
Yeah. I guess there is the other question, Don. I think you're right. I think trade secrets clearly is an important thing that maybe a company may overlook. How do you make sure that you're actually capturing the value in the trade secret that you bring to that agreement? Outside of the issued rights that may be the core of the agreement, there's lots of other pieces that are going to make it more valuable, are going to make you the target for licensing, not just that technology, but the right formula for implementing the technology. And some of that goes to the trade secrets, right?
True. And I'm going to add something to this. One thing is, if you have a reward system for patents, because that's an easy system to have, you get a patent, you get money. You should have a reward system for trade secrets. That'll also force you to codify your trade secrets, because now instead of not just writing a patent, it's a difficult procedure, but instead of writing the patent and prosecuting the patent and all that stuff, with trade secrets, you don't do those things, but internally you can have the process. And the people who come up with trade secrets should be rewarded in the same way that you reward people who develop patents for you.
Right. You know, it's just like patent awards, just like in a larger company, you might have a patent wall, you might have some financial incentive for information disclosures all the way up to the issued patent. Same thing for trade secrets.
You know, Dana, this is Jim. I would just extend on that a little bit, especially when we're dealing with smaller companies. We recommend a trade secret reasonable measures plan, which really lays out that you need to treat them as if they were patents to be filed, meaning write a detailed specification, inventory them, and then make sure that you let the employees know that these in fact are considered secrets. So they should not be discussed with potential vendors, suppliers, customers without the appropriate NDA or other protections. So education is a vital part of maintaining a strong trade secret program.
Excellent. Internal education, certainly. Well, let's get, can we further on that a little bit more? And Don, in your presentation, you talked about assuring subcontractors and remote contractors are properly handling your IP. I guess that's one bucket of issues. Another is, and we've gotten some Q&A, some questions from our audience on the rules for employees that are developing technology on the weekends. You know, what type of structure do you put in place to ensure that you're identifying what belongs to the company and what belongs to the employee? Can the employer own any part of that IP? It's just a hobby that's developed on the weekends. What do you do with that?
For me, this question's for me, Dana.
Jim, you can take it, or Don, or Nikos, any of you.
I'll jump in here. To me, there's a little bit of humor part of this. I don't know why, excuse me, but it's you know, I've heard of bizarre things where people, you know, who love to sail on the weekends, they, you know, work on developing better sails, and the company that might be doing something completely different decides that they own the sail. That's what's important, the sail design, you know, that's what's important about having the contract. I think I'm not familiar with all the rules in other countries, because I believe that European countries actually have maybe some more protection for inventors than the United States does. In the United States, the company, you sign the contract, the company can own everything. Right, that's it. It doesn't matter. You can invent a sail and get a patent on the sail, and they own it. But not all companies do that either. And I think as time has gone on, you've seen companies be more reasonable about such things. But they usually will tell you you have to tell the company. You may want to even tell the company you're working on it and make sure that it's clear and who will have ownership.
Nikos, can you give us a European perspective?
I can actually, indeed, yes, I can have an experience as well with this. Definitely, in Europe, we are a bit more protected. So companies know they don't own anything. Everything, of course, is written in the contract. The problem comes when really you are doing some overlapping work. And maybe you're not developing the exact same product as you do in your normal job, but something very close to it. And that's actually where the complication starts, of who owns what and what kind of knowledge the employee used during his weekends to create this product. But definitely the more you can differentiate from what you do day to day, the better you are protected as an employee and as an individual. But the closer you come to your day-to-day job, then I'm afraid that there will be some complications.
Yeah. So on this kind of it was kind of a compound question. We just addressed how do you deal with the employee who on a hobby on a weekend is developing a better boat or a better sail or something. And certainly on that, I think all of you are saying good communication, maybe actually have incentives for within the company developing things that are within the business stream, but just good communication either way. What on the first part of the question I asked, which was, Don, you mentioned in your opening, what's the effective way to manage subcontractors, making sure that they're properly handling your IP? It's a slightly different question. It's certainly a different question than your employee that may be doing this hobby. It's actually you're trusting them to take your IP, but also handle them potentially in different geographic places, right?
Yes. I think that from the standpoint of those who are managing IP in a company or responsible for IP, whether that be the patent attorneys, the copyright attorneys, I think their job is to educate people that are more closely with manufacturing and about IP and what is necessary to protect the IP, so that as the people who are going into the subcontractors and vetting them out, whether to choose them or not, or studying them, have an understanding of what you should be kind of looking for. When you view the factory, did they make you sign into the factory? Did they make you identify what company you're with? Did they keep you isolated from other people's assembly lines? And sometimes, people do unbelievably stupid things they think is good, but they'll like whisper to you, "We'll see how they're doing it over there." As soon as you hear that, don't think that guy's doing you a favor, because most likely he's going to tell the other guy what you're doing over in your assembly line. So, that's part of it. Something simple like scrap policy. What do you do with the scrap? So building a PC board, again, I'm going to be influenced by what I know about here, and it's all about electronics and stuff like that. But you're building a PC board, right? And, they break. I mean, some of them don't work. They don't pass final inspection. Well, you scrap, where do they go? Do they go out the back door to some guy who does something and then sells them? Or are they promised to be crushed? And do you have someone that actually watches it be crushed, witnesses the thing being completely crushed? And then, of course, how your software is handled, practices such as you should, you should, everybody, it should only be on secure servers. Perhaps the software should be encrypted. Everybody who gets access to the software, where they download it onto their desktop or their laptop, their name is listed. Even though it's hard to keep people from walking out of companies with secrets, the fact is they know if they signed a piece of paper, that's going to put them a little bit more on edge to, not to do something wrong. So it's those types of things that that I believe the IP people in the company have to educate those that are going out to the manufacturing plants, because I doubt that very many attorneys are spending a lot of their time at these big subcontractors, whether it be a Flextronics or Foxconn in China. I just don't think many of them are in those plants as your people who are taking your products when they're spending half their life in those plants.
Don, this is Jim. The other thing that I would add is also take in mind any improvements that your subcontractors or vendors may make, and be sure to try to obtain those rights as part of your initial contract. So protect what you have and make sure you capture what you pay for.
Yeah, absolutely.
Yeah.
Sorry, Nikos here. Just jump in. One thing we have seen is that the SMEs in general, big organizations understand this, that the transfer of ownership of IP developed is not in the actual contract. And this is one of the key issues, is that companies or individuals believe that just because I pay someone, I automatically have the right to the IP. Actually, the IP belongs to the creator, and the creator transfers the IP to the company.
Nikos, that's correct. And I think that in your license agreements, you want to be very clear that the only thing being licensed is what has been licensed in that agreement. Because I guess I've never personally witnessed this, but I guess there's problems sometimes where people claim because they got a license, they got more IP than they thought they got.
But for example, if we talk about subcontractors, let's say that you want to build a software product and you employ a developer to do that for you. In that sense, actually, who will be owning the software code that will be developed? Is it going to be the company or the developer? And unless
it should be the company, Nikos. I mean, that's
no, it should be. Yeah, absolutely, yes. Yeah, if you have clear agreements, what I'm saying is that the SMEs should be aware of that. Absolutely, I agree with you. But in subcontracting agreements, there should be such clauses to transfer the IP.
Yeah, and that agreement should be very, very clear on those points too. So Jim, this is a good question for you to take on. Another question that we've gotten from the audience was, how do you most effectively scan and monitor existing patent IP landscape, particularly for SMEs? What resources do they have to do that job well?
So there's a couple of things to look at. First and foremost, the data that's available now simply on the patent office websites around the world is so much better than it has been historically. So we encourage, especially smaller companies, to simply go and search on those sites, not only by technology description, but also by names of the CEOs or lead engineers that you're aware of from your competitors to see what type of work they've been doing. Aside from that, there are also now several companies that offer analytic tools or platforms that are based on statistical analysis or artificial intelligence or word searching to try to create summary charts showing who has dominant patent portfolios in specific technology areas and how those have changed over time. But ultimately, we always emphasize that those tools are used for screening. And in the end, you need to put eyes to paper and review the key patents of yours and the others in your industry to really understand protection. But those screening tools can be very helpful to sort through the pile of options to get to what's most likely to be important.
Yeah, and it may be a combination of the two, right? There is, particularly if you're small, on the very, very small side, doing some of your own due diligence. Your eyes on your technology are probably better than an outside company, but the AI tools seem to be getting better and better to be able to kind of fill in what you're not looking for. Exactly. I'll mention, particularly in the COVID side, the U.S. Patent and Trademark Office launched a tool called Patents for Partnership, which is supposed to list a number of patents that are currently available for license, particularly addressing COVID issues. It's a role that the U.S. Patent and Trademark Office hasn't usually played on the licensing side. Some other offices have, but that's certainly one tool. But then just the common databases that the major patent offices have been providing are also great tools to just do some due diligence if you know what you're looking for.
And one follow-up point to that we always share with earlier stage companies is be aware that others are doing the same to you. So they are searching your portfolio both to understand where your business may be headed, but also to identify who are your strongest engineers. So we encourage those smaller companies to make sure they have the right employment agreements in place with those lead inventors so they're not recruited away.
Makes a lot of sense. So we've got a few more minutes here. I see some of the questions we got a question in the Q&A about how to find the value of IPR and what are the steps for valuation. I think this is the first in the series of 3, so we'll get deeper into that in one of the later publications. Likewise, there's certainly questions about what metrics you should be using to determine the percentage of revenue spent. And some of those go toward, we'll cover kind of in the licensing. But can we go back and hit some of the major points for this? All of you have talked about the process and just thinking about how to effectively manage. I guess, an initial question is, who should be involved? Who in your company should be involved in setting the IP management strategy? And I put that, John, you want to start taking that and we can kind of go around the table?
Yes, I'm going to answer by saying, a broad group of people. So I think a lot of times people immediately go to the Chief IP Counsel to do all that work, and certainly they probably have the most significant input. But you definitely have to get the business people involved. Depending on who you might have in branding, those people involved. I really think it's going to be a cross section of people within the company, so that and some people probably maybe even going to be resistance because we're all so busy to have some resistance to it to discussing this and getting involved with it. But I think you kind of almost have to pull them in. You right across the company. So that everybody understands what's going on and everybody has input. I talked about the people who spend their lives making sure the products get built on time and built with quality. those people are important to this because they're the ones that are going to your subcontractors. The engineers clearly, your senior engineer managers or directors clearly should be involved with all this. And if for no other reason, when it's all done, you will have consensus that this is what, this isn't just some crazy thing the law department came up with. This is what we all have contributed to, and this is going to set our guiding principles.
Don, I certainly agree with you, especially from an operational standpoint. But we always recommend you go one step higher, which is really to have a committee of the board of directors that is responsible for the intellectual property of the business. Again, if you refer back to that S&P 500 chart where the intangibles represent 80 to now 90% of your value, we think it's incumbent upon the board and the C-suite to understand what those assets are, how they're being deployed, and how they're being used for shareholder value.
Maybe I can add something to this as well. I agree with what Don and Jim said. What I will add also is very important to understand that the technical domain where the patents and the research is done and the IP are sometimes disconnected. It will always, what I found very useful is to have someone that can communicate between the two, what we call an IP champion, that can really look into what's happening in the technical and the research domain, that can communicate that to the IP.
Thanks, Nikos, and thanks, Don and Jim. I think our time's just about up, but there's some great questions that we didn't get to answer, universities and other things, and we'll try to answer those after the event in writing. But I encourage all of you to take a look at the publication. It really goes a little bit deeper on some of the things we talked about and answer some questions we couldn't get to. But with that, I want to turn it back to Claudia to close us out. And I want to thank the three of you for interesting conversation, and thank everyone else for listening, and hopefully it was useful.
Thanks, Dana, and thanks so much to the excellent panelists. This has been extremely interesting. And I explained before, this presentation and a recording will be available on our 4IP Council's website tomorrow, 13 September. And later today, you will receive an email inviting you to complete a 1-minute survey about this webinar. So we will be very thankful for your feedback. And please visit our website for details of our forthcoming webinars. You can see we have on the 8th of October a webinar on IP strategy for researchers. We also discuss on the 15th of October whether the owners of essential patents have an obligation to license to everyone who asks for a license, or rather to give access to the patented technology. We discuss on the 27th the value of patented, of intangible assets, and on the 17th of November, the idea and the license of valuable assets. So I encourage all of you to join those webinars and register as soon as possible. And thanks to everyone for listening, and to the panelists, and Dana, thanks so much for the great job you have done today. Extremely interested.
Claudia, thank you so much. This is Dana. Just one last thing, just for folks that want to access the publications, they're all up on the LESI website, which is www.lesi.org. You'll see a big banner on the top of the page. Thanks so much.
Thank you. Bye-bye.